like to go ahead and call the meeting to order. Welcome to our February 20th meeting of the Multidisciplinary Committee. I'd like to have the roll call.
Dr. Klingborg.
Here.
Dr. Drusis.
Present.
Dr. Pollard.
Here.
David Johnson.
Here.
Jennifer Laredo.
Here.
And Dr. Sullivan.
Here.
We are missing today, not with us, Dr. Grant, Christy Pulowski, and Diana Woodward-Hagel.
Do we have quorum?
Yeah, we're missing 3. We have 6.
Okay, so we have 6 members present, so we've established quorum.
Yeah.
Item number 2 on our agenda, committee chair's remarks. Well, I think I'm going to reserve the right to remark for later, so I'm going to turn this over to my committee members' comments. This is a new line item to us, and I think it's just like open mic night, so.
Dangerous.
Yeah. And then the introductions, would this be introductions for people in the audience? Is that?
Yeah.
Okay, so if you would like to identify yourself, members of the audience, please do so now, and we will start in the front over here.
Cindy Stabley, RBT, CVMA, and the Sacramento Valley Veterinary Association.
Nancy Ehrlich, the California RBT Association.
Valerie Fenstermaker, CVMA.
Graham Miller, CBMA.
Leah Schuhout, CDMA RBT Committee.
No affiliation.
Erica Hughes, Safety Net Association.
Alvarado County Animal Services.
I'm Pastor UT David. Ethan Mathis, Veterinary.
I'm in Drummond Veterinary.
Cheryl Waterhouse, Veterinary Medical Board.
Patrick Clay, Department of Consumer Affairs.
All right, thank you. Agenda item number 3, review and approval of the October 17th minutes. I have one correction here, and that is on the second page. It's instead of May Warner at the very top, that is Meg Warner, DVM.
Oh, thank you.
Any other additions, subtractions from the minutes from the committee? Anything from the audience? Okay, a motion then to approve, please.
So moved. Second.
Any discussion? Okay, we'll call for the vote.
Dr. Klingborg.
Approved.
Dr. Drusis.
Aye.
Dr. Pollard.
Aye.
Dave Johnson.
Aye.
Jennifer Laredo.
Aye.
Dr. Sullivan.
Aye.
Motion carries.
Motion carries. Agenda item number 4, update from the Complaint Process Audit Subcommittee. Dr. Pollard, will you please walk us through this? This is your baby.
Yes. So Drs. Grant and I met a few months ago, and probably was the, I think, 5th or 6th time now over the last 2+ years that we've been doing this, that we got together either together or individually. And I think, as I've outlined, first I want to mention if there are any questions or detailed clarification needed from what I put in the packet, just say the word. But I would just generalize by saying this was the first time that the entire collection of cases that we reviewed were recent, were very well organized compared to previous ones. Most of them took place over a shorter period of time. And I would just say that I think the process is improving, and I think I'll stop there and ask for any questions or clarifications.
I did have a question under your specific observations in that first paragraph, the second line, describing medical surgical issues in layman's terms is important. I thought that was interesting. These are expert witnesses, and so I guess I'm wondering who's the audience and how does that improve the product?
I think the best answer to that is the audience is the administrative law judge. So this is a person who is not a veterinarian, doesn't have any medical training, but is a very intelligent person who can understand the language if it's explained properly. So I think it's the task of the VMB and the experts in this case to do that.
Great, thanks. Questions from the committee on the Complaint Process Audit Subcommittee? Any, you have comments?
Only comment, and I know where Dr. Pollard was going with this, when he talks about it being ethically challenging for the expert witness to look at these cases, it's very difficult, and he used the term fair. And I think what we're looking at is it's the objectivity of the review. And that is, you can't get caught up in the emotion of the complaint or perhaps the veterinarian may have reasons why there was poor judgment. And that's what makes this job unique and challenging, is that as a subject matter expert or an expert witness in these cases, you have to remove those layers and look at specifically the facts and whether or not the treatment, the decisions were pertinent to the outcome of the case. And I think any one of us who've seen a expert report has been caught up in perhaps whether one party is more believable than the other. And that is really left to the decision of the courts. And when you put your experts on the stand and you have cross-examination, that's where that really kind of plays out. But when you're looking at these reports, you have to keep in mind that this is purely based on evidence, and evidence is that of the medical record and perhaps anything that came through the interviews and the investigation. And it's difficult not to want to judge credibility in these cases. So I think to Dr. Pollard's point here at the very last paragraph, it's ethically challenging to be fair. And really what that comes down to is removing the emotion from what you're reading and not try to be the judge and jury in terms of credibility, but just weed out all of that and look specifically to the facts of the case. And I don't know that anybody's expertly trained to do that. So it is challenging for us to find individuals who do a better job at that than others.
Okay. Yep, questions or comments from the audience? Please come forward.
Okay, my question relates to...
Will you identify yourself?
Bonnie Boots, no specific affiliation. Just kidding. Actually, my question relates to the fact that, do you give the complaints to the experts? Because I've run into a couple of situations where the expert witness buys into pretty heavily the wording in the complaint, and as we know, the complaint is the complaint. I mean, it's an animal owner that's upset for whatever reason, and the expert buys into that and tailors their opinion based on that. There's another expert that I deal with all the time who has said that she doesn't even look at those complaints at all sometimes, and never does that until after she's written the opinion. So my question is just that, is it a good idea to be giving those complaints to the experts, and what value does that give the experts? I mean, do they really need to have that information?
We had, this came up in maybe a year or so ago. We had a similar review of a case sit-down, and I think it was I that mentioned it. One of us mentioned that, so the short answer to your question, does the expert get the complaint? And the answer is yes. They get it in the packet, and Anne Marie can correct the details of what all is in it. But I think what's telling that we came to conclude was the order in which the expert reviews the packet, I think, has an influence on how he or she writes the opinions sometimes. And it was pretty unanimous in concluding that the complaint shouldn't be the first thing they read. The medical record is what we read first. I
guess my question is, why do we give them the complaint at all? I mean, is it really and this is something for you to decide, but is it really necessary for that expert? And in a way, isn't it more of an ability to stand back and look at the medical record and make an accurate evaluation based on standard of care if they don't have all the carrying on that's in the complaint to kind of, even if they read it last? I mean, my question is, do they need to see it at all? They know there's a complaint issued. And do they
Well,
really need
if-
to see what the complaint is?
If you didn't include the complaint, by the same logic, you would say there shouldn't be opportunity for the respondent to reply either.
Exactly. So it's standard procedure, not just for the Veterinary Medical Board, but in, all expert witness training, that the experts see the complaint, and it's because that's the story, behind what happened. The medical record only gives so much detail about the actual, whether it's the diagnosis, the treatment, the dispensing, but it doesn't tell the whole story. And that is a disadvantage to, obviously, someone who would be reading this and doesn't know what the issues are, but it's also a disadvantage, as you know, to the respondent who needs to be able to tell their story. So as much as the complaint's included, so is the response of the respondent to the complaint. So that should be equally weighted.
Then perhaps my suggestion would be that you suggest to the experts.
We do when we train them.
Oh, that they don't use that as being their.
That's
first
not
thing.
factual.
Yeah.
That's not what their substantiated evidence is not based on what the complainant said happened. That is one factor that they must review so they can get the totality of the incident. But they also review the respondent's response to that. And, as Dr. Pollard and Dr. Grant alluded to, they've done the case reviews both from, that kind of beginning to end where we receive the complaint, we get the respondent's response, we do the investigation, and so on and so forth. And then they've reviewed it from the outcome backwards. And it absolutely changes your opinion of what occurred. So we tell that to our experts during our expert witness training, that do yourself a favor and read the entire file, starting from beginning to end, and then do it in reverse. So that way you're getting, a full picture without being persuaded by who you believe is more credible in this case, because that's not their job.
That's great to
Yeah.
hear, because now I've also decided in the hearings, that's going to be one of the first questions I ask the expert
Yeah.
is how much weight they put on
Yeah.
the complaint. Thank
Yeah.
you.
You're welcome.
Other questions or comments from the audience? Anything else from the committee? So we do tend to hear from the complaint process audit subcommittee every other meeting, and we'll ask then for the next report at what I'm assuming will be the August meeting. Dr. Grant, who's been a member of this subcommittee since its inception, will be terming out in May, and so there will be a new appointee to that subcommittee. Agenda item number 5, discussion and consideration of recommendations from State Humane Association of California, the California Animal Control Directors Association, and the California Veterinary Medical Association regarding public and private shelters and minimum standards and protocols for shelter medicine, with the potential recommendation to the full board. So in our packet here, we have the work product of a meeting between CACTA and SHAC and CVMA, and some issues have been identified in that meeting, at that meeting, and then also some recommendations. So at this point, that if we wanted to discuss amongst ourselves, certainly we could. If we want to get some orientation to the document from the players, then we could, instead of starting here, we can start there and have some conversation, and then bring it back and talk as the committee. Does that sound okay? We invite those players to come up? Okay. So in whatever order, why don't we, Erica, why don't we have you actually come up and kind of get this ball rolling? And Eric, if you'd like to as well, since I see a couple of microphones, that'd be great. And please identify yourself for our vast audience.
Good morning, Erica Hughes, State Humane Association of California.
I'm Eric Anderson, California Animal Control Directors Association.
So thank you for being here and for preparing this. Do you want to give an overview? I mean, we've read it. I'm sure everybody's read it. We're familiar with it. Is there anything specifically that you want to underscore or highlight, or do you just want to come up and have input as we tackle specific issues? And also, committee, if there are specific things you want to ask at this point, this would be one of those opportunities.
I just want to say that I think we had a meeting on December 8th with representatives from CACTA, SHAC, CVMA, all to the California RVT Association, UC Davis Shelter Medicine Program, the chief veterinarian from the County of Los Angeles Animal Care and Control, and Bonnie Lutz, and I'm not sure if I'm leaving anybody out. If I am, just let me know. But I think it was a very, and Anne Marie was there, and yes, Dave Johnson, and Dr. Druses, yeah, sorry. I was actually home and participating via teleconference, so sorry. Hazy. It was, but I want to say I think it was a very productive meeting, and I think it was, I think it's important for us all moving forward to sit down and talk over these issues among ourselves, and rather than stay in our silos and figure this out, because I think each one of us from our different perspectives lends a really key element to the solution, and so I'm glad that hopefully that meeting was the beginning of that process. I think it's really important. So in terms of the recommendations in this document, there were some things that we had unanimous agreement on, and then there were other things where we haven't quite reached a unanimous agreement yet, and so and those were noted here. But I think, one of the key issues that we were all struggling with was the idea of the question of whether or not a shelter should be required to have a premises permit for if staff is going to engage even in just very basic healthcare tasks like vaccinating and treating for parasites. And through a lot of discussion that I had with various types of shelters throughout California, both public and private, and large and small, I think it became clear that it's important for shelters to have a formal relationship with a veterinarian. But from our perspective, what was concerning was that we felt like there were, because of the liability that's involved in being the managing licensee, that's a barrier to shelters being able to find a veterinarian who's willing to be on the premises permit. And so, and that in many of the shelters, especially small ones, that don't have a hospital, it's just kennels, maybe a small police department that has, maybe 5 cages, and that's their shelter. Kind of looking at that and having them evaluated in the same way that a full-fledged clinic is evaluated just doesn't make sense. And so I think the most important thing that came out of this was the agreement that we would look at drafting. We wanted to look at our recommendation is that sorry, let's get this straight. The recommendation is that the MDC recommend that we explore drafting minimum standards for the shelter setting that are different than the minimum standards for other settings.
I don't have anything specifically to add too much. I think Erica did a very thorough job of summarizing that. And I would just reiterate her comments. Other to add that I, CACTA, appreciate the opportunity to provide input into this process because, as Erica said, I think it's important that, shelters, whether they're humane societies or public agencies, are sort of a unique animal in this discussion, and kind of the obligations, responsibilities, and the context in which we work is a little bit outside of the norm for most veterinary practices in terms of the patients that we see or the clients and animals that we're seeing, and questions of ownership and so forth. So, as we go ahead, I think keeping in mind that reasonable and appropriate regulation is something that we all agree on, and it needs to be in place for all these facilities, but also some awareness of the uniqueness of that environment and the obligations and demands that are placed on them also needs to be considered in development of the policies that we put in place. So I think with a balanced discussion on that, we're poised to be in a good spot.
Any questions from the committee at this point? Yeah.
But my question is for CVMA.
Okay. So we're going to give CVMA a chance to kind of give us the quick overview as well. And, yeah. Yes, Jennifer.
I had two questions. One is just on the first page of the document, third paragraph down, just the wording that in 2008, the VMB adopted this policy, and then further down in the paragraph, it says the VMB has since taken the position that the policy is an underground regulation. The wording was confusing. Did we change our minds after having this regulation? Anybody? Okay. Second question, since I have some experts in the room, it's not even about the whole concept, it was just a technical thing. Last page, issue being all dogs 3 months and older are required to be vaccinated for rabies. I actually reviewed the code several times. In some places, it says 3 months, and in some places it says 4 months, and other places it says within 30 days of being 4 months. I was under the understanding that rabies vaccine is approved for use at 3 months of age, but required at 4 months. Are you guys able to clarify that?
Yeah, that's my understanding as well. I think you're correct in that.
Yes, Dr. Sullivan.
Yeah, looking at this with the issue of small shelters, I can see where we're looking at when they're on intake for vaccinations and parasite control. I can see your issue there. However, I don't know of any kennel or shelter situation, how small, isn't going to come up against some animals that have infections or some animals that get injured. How do those facilities handle those situations if they don't have oversight with a veterinarian? How do they get antibiotics to treat them? How does that work?
So a lot of them have, I would say almost all of them have a relationship with a veterinarian. It's often a veterinarian in a community practice in town. And they work with that veterinarian on protocols, and when things if things start going south, then they call the veterinarian in, or they bring the animal to the veterinarian. So it's not that these small shelters aren't working with veterinarians; they just don't have premises permits, and so it's not in a formal way under the law that they have. It's not a formal legal relationship that they have with the veterinarian.
But I would see that as our avenue to correct this problem.
And which is why our recommendation is to have minimum standards for animal shelters and require a premises permit at each shelter with a veterinarian as the managing licensee.
I'm sorry, so you are recommending that be part of the minimum standards?
Correct.
Oh, okay. All right.
Yeah, I mean, our concern is that we don't want to set up shelters who aren't able to comply with the current minimum standards for veterinary hospitals. We don't want to set them up for failure. We want to look at shelters and their unique needs and what's going on in these shelters and tailor the minimum standards to that. And when I say minimum standard, it's not about, whether they're going to get better care or worse care, but about what makes sense in that environment.
So you're not looking for an exemption for a premises permit, but you're looking for a way to accommodate that small shelter for having veterinary oversight with with some responsibility for that shelter?
That's correct, and one of the things that we want to be really cognizant of is the community, it'll be one of the veterinarians in the community who ends up taking that role as managing licensee, and we don't want that veterinarian to be exposed to an unreasonable risk of liability for being on a permit in a shelter where the veterinarian really isn't present. So in a typical hospital, the veterinarian's there, the veterinarian has the ability to hire and fire and set all the policies and protocols, and that's not the case for a shelter where the veterinarian's over here in his or her practice and the shelter's here. The veterinarian doesn't have control over a lot of things that go on in the shelter, but we still think it's important to have that relationship. So we want to tailor this premises permit process to recognize the unique relationship that these shelters have with their community veterinarians.
But many of our licensing managers are not owners of their clinics. That's not a prerequisite. So I think it can fit. I think we can get it to fit.
But I think one thing that distinguishes the situation where you have a licensing manager who's not there is that you have other licensed veterinarians in that practice who are overseeing what's going on, whereas in the typical small shelter setting, there are no licensed professionals there.
See, my angle where I am coming from is we need to rethink of this type of practice just as we think of a herd health program in a large animal practice. That's how we have to approach it, where the veterinarian has an understanding of the operations of the facility, just like a dairy, and look at it more in a herd health approach than an individual care. And I think it's very doable. As a matter of fact, on that first sentence with issues, the first paragraph, the last sentence is, therefore the definition could include, I say does include, animal shelter. I think we have to get to that framework of if you are taking in animals that have potential health risks and you need to do preventive medicine, there's got to be some type of oversight, and if that's our end goal, I think it's doable. I was under the assumption that you were coming from a standpoint that you wanted a premises permit with no veterinary oversight, and I think what you're describing is very workable.
Thank you. We hope so. I do want to say that we are concerned that that there may be shelters that are unable still, even if this change goes into effect, there will still be shelters that are unable to find a willing veterinarian to be on the premises permit. But we feel like there's really no way to know until it's required whether or not there's an issue. And then if we find there is an issue, then we're going to have to look to see how to address things then. But for now, we feel like it makes sense to put the requirement into place. Hope that everybody can comply, and if people can't comply, then we have to figure out what the barriers are and go from there.
Dr. Dreestes?
I think it's important to point out that this discussion certainly has taken place at many different levels over the last 2 or 3 years in the state, and the opinion assessment theory that there are organizations out there that would otherwise not be able to obtain the services of a veterinarian. And I believe at our December 8th meeting, Ms. Lutz even asked a question similar to what I'm about to ask, and that was, well, if there are these organizations, these locations, if you will, name them. Where are they? What are their names? And if I remember correctly from the meeting, the response was no one could even name one single one that was otherwise unable to acquire the services of a veterinarian. And I agree with Dr. Sullivan. this is a herd health issue. It's just that the herd is made up of smaller animals that are constantly coming and going, but there remains a herd, whether it's 5 animals or whether it's 500. And from a veterinary medical perspective, that has to be managed. And the only way that the board, the state of California, has the ability to manage that is through a premise license, through a veterinarian, through best practices, if you will, or as we're calling it later in the agenda, it is, what are we calling it? I'm sorry. From the premises permit minimum standards applicable to the various different types of the practice of veterinary medicine. And that's, I believe, the end goal that we share and that we need to get on board and place into practice.
Yes, Jennifer.
Just stating my opinion. I have a lot of opinions. The recommendation that RVTs and veterinary assistants can perform care based on the direct orders of a veterinarian, I think that's really important because I work with a veterinarian who's very meticulous and she writes down certain parameters and what we can do. And there are still times that an animal comes in and doesn't meet any of that criteria and I have to call her. She's not always at my facility. So I had concerns previously with having a premises permit without a managing licensee. I really like the way this is worded, so good job.
Can I get a clarification? Are you looking at page 4 with the, okay,
That's something
You
we
were?
need to do. The agenda packet.
the 4840B recommendation? I was a little concerned about that language because it almost looks like it starts to limit the RVT's existing ability. If you strike that an RVT may perform animal health care, which is broad, and replace it with necessary and prompt veterinary care, that's fewer services that could be provided by the RVT. I understand that you're probably trying to limit the scope of what a VA could do, but perhaps there should be 2 different provisions. One for the RVTs that can already do animal health care services rather than limiting the scope of what they can do, and then just creating a new one for VAs so that it's necessary and prompt veterinary care. That's all.
I don't think the descriptor was intended to limit anyone's scope. It was taken from the civil code, and so we were trying, since we were referencing the agencies that fall under the city, county, or contracted with city, county agencies, we were looking at the civil code section, if I recall, and Dave and I talked about this at length, Dave Johnson. So it wasn't an attempt to limit the scope of practice for an RVT or a veterinary assistant. It was really to try and mirror that requirement that exists for animal shelters, which is to provide necessary and prompt veterinary care. And we looked at those triage services that we're talking about here as necessary and prompt care. So I guess in some ways it was to refer to the mandate on the shelters that exists in civil code section and marry that with this understanding that it's both RVTs and VAs that can be responsible for that triage. Is that accurate?
Yeah, I think that's fair. And as you mentioned, that is a statutory language.
Right.
That necessary prompt is taken directly out of the obligations on animal shelters.
Right, so I think we were
You're
trying
aligned
to
with that.
incorporate that into the Business and Professions Code so that they link those 2 obligations.
But I guess the question is whether we want to limit it to what's required under the civil code.
Yeah.
Because it's not, that's necessary and prompt is not the only veterinary care that shelters provide to
Right.
animals that are impounded. So it may, and especially if there's a premises permit with a managing licensee, when you're talking about ongoing care, I think it probably does make sense to allow that ongoing care to be done via a direct order, written order, a telephonic order.
So my intention, and I've done a poor job as chair here, was that this was going to be an introductory part of the conversation from 10,000 feet, and now we're on to page 4. So I'm going to ask you to sit down, thank you. And then CVMA, if at this point, would you like to make any comments from 10,000 feet? All right.
Valerie Fenstermaker, CVMA. Just as an overview from 10,000 feet, back when we were asked to form a premises task force, we were also asked to look at the shelter minimum standards, which we did. We submitted language, I think, in June of last year that was specific to RVTs, which was the original request. And that was to expand the minimum standards to allow for written protocols that could be developed by a veterinarian for a shelter, meaning the veterinarian didn't have to be there all the time. And following that, there were, and that has been submitted to you. Following that, we looked at veterinary assistants at a subsequent meeting, and there were more limited protocols that could be done for veterinary assistants, and we still stand by those. After that, somehow, it became a little strange for us because we were assigned to be in a second or another task force that was much more expansive and started including changes to the Business and Professions Code, which we don't agree with at this time. That's a much larger issue, and from what we can see and you can see in what's been submitted, we don't agree on most of those points that are in the document. And we can get more into the specifics of those later, but it's important to note that whether you have a large shelter or a small shelter, whatever's decided in minimum standards applies to all shelters. I don't know how you define what's going to apply to a small shelter. And if they all are required to have a premises permit if they're practicing veterinary medicine, and if those regulations are across the board, they will apply to the largest shelter if those standards are relaxed. And we're very concerned about that. So I would encourage the committee to look at the big picture and to stay within regulations, because our belief is that what applies to the care of all animals includes what applies to shelters, and that we shouldn't have less quality of care for a shelter animal than we do for owned animals. So I think that's my 10,000-foot overview.
Thank you.
Thanks.
Any other members of the public that would like to comment on the document in theory? Yes. Come on down.
Nancy Earle, California RVT Association. I just want to be sure that whatever changes are instituted don't blur the lines between an RVT and a veterinary assistant. It's fine for veterinary assistants to perform procedures in a shelter that they're allowed to do in a private practice, but I don't believe that the training or education of a veterinary assistant should allow them to have independent judgment and the type of things that RVTs are trained to do. So we need to be careful that while trying to make sure that the animals at shelters are getting the care they need, that we don't blur the distinction between people with licenses and people off the street.
Any other comments from the public? Okay, so let's go through this, and let's start with issue number 1, the prevention and treatment of infectious disease in shelters. There's a lot of background there, and Jennifer, I agree. I thought there was confusion there in the third paragraph where it sounded like an interpretation of regulation had changed. We've seen that before, so it's not unprecedented, but it's always interesting how different players can completely pull the rug out from underneath you at times. And then we have a recommendation here at the bottom of the second page. Basically, the recommendation would be to develop minimum standards for an animal shelter facility similar to the recommendations for different premises that we'll be talking about later today, the work product of the CVMA Premises Task Force. These minimum standards will take into account the unique circumstances and needs of an animal shelter and should only address the areas of the shelter where veterinary medicine is being practiced. So, conversation, discussion on that amongst the committee. Dave?
Well, let me start by thanking everyone for the document and the continued input, because it just allows us to continue discussing the issue. First of all, just for background, Dr. Druses and myself teleconferenced in to the December 8th meeting, so we have the background information there from that meeting. Dr. Pollard and myself have worked on the subcommittee, and basically our report that is in the minutes from that we filed at our last meeting, nothing has really changed opinion-wise from that document, so that still stands there. As I was preparing for the December 8th meeting, I'd written myself 2 notes as a reminder for thoughts. One of them was, should we carve out exemptions in the statutes to address some of the issues that have been brought up? And should we make the necessary statutory changes? Or the alternative was, should we stay within the regulations and work within the regulations to address some of the issues? And as the meeting went on, and I think Anne Marie, you did a fabulous job of bringing up some points for discussion, I think it's premature to do anything in the statutes, either adding people to it, names to it, or putting exemptions, without us first looking at what can we do in regulation. And so I came away from the meeting, and it just reinforced that I think we need to develop minimum standards for shelters. And then this nice document that we're going to be discussing, that Dr. Grant and Dr. Sullivan put forth for our next agenda item, it really kind of standardized everything, and it lends itself to creating a section within 2030 for animal shelters. And the very first thing that you would start with would be the definition of an animal shelter and what constitutes it. And then I think we need to bring in all these documents and issues that have been brought up. Valerie, you talked about the June 27, 2016 document that I have here. Excellent document, has some wonderful statements in it that literally belong in a minimum standard type of a document. I've brought the issue up before when we're talking about veterinary involvement in animal shelters. I think we can learn and glean information from the Animal Welfare Act, whereas we have many research institutions in the United States that regularly do veterinary things to animals, but do not have a regular full-time veterinarian on staff. And they go with the concept of an attending veterinarian. And that attending veterinarian, those responsibilities are outlined very specifically in terms of their responsibility, their oversight, the protocols that have to occur, the fact that they have authority to make change. And one of the specific things that they have responsibility for is sanitation and housing, and not just veterinary care. So again, there's other places we can look for information when we're talking about animal care. Most of the issues that were brought up in this document, I think, belong as a discussion in minimum standards first before we go to look at, make any type of statutory change. And essentially, I think there's a language that will clarify the permits that are required and what a premise permit, the responsibilities are. I think we can address the issue of the veterinary care on intake. And to answer your question, Jennifer, the frequently asked questions on the veterinary board site still says it's okay to provide those services. I think the point that was made was that it was basically an underground regulation because there's no reference to an authority to perform those tasks, but it's still on the frequently asked questions. And then my comment for you, Anne Marie, I pulled this up last night before I came up here. this is actually an excellent document. I don't know how recently it was updated, but it really provides a lot of information. I wish it wasn't quite as hidden to find, and I think this is an excellent document that maybe we could work and recommend with CVMA to get out there into the public to let the profession know about the responsibilities, and maybe there could be more clarifying information about who is, instead of just saying, if a shelter is providing veterinary care, you need a premise permit, maybe expand that out a little bit so they understand who truly needs the premise permit. So again, just in summary, I think we need to focus our discussions on developing minimum standards. What of these issues should go into a minimum standard discussion? And then I also think that the discussion should start with this committee. I think this committee should develop a framework and the information and then send it out into the community for further discussion, as opposed to us waiting for something to come in from the community.
Can I say that I think you're a national treasure, Dave Johnson? You've been at the forefront of this for a long time, and the minutes in our packet at this meeting really capture a lot of what you and what Dr. Pollard worked on. But Dr. Drusies has been part of some of these subcommittees as well, because we've been working on this issue since October of 16, I believe, when we had our meeting down in Riverside. So we've been really determined to try and move forward. We're talking about the first recommendation here regarding developing minimum standards. We've heard from Dave Johnson. Other comments from the committee at this point on that recommendation?
If I could sneak to page 2. The last sentence, second paragraph, where Shack details if these shelters are unable to find a suitable veterinarian, a different statutory regulatory framework should be considered. And this is one of the points at which the CVMA is not yet prepared to sign off on. It seemed like from Eric and Erica's presentation and what Dave has said in the past, people, and Dr. Sullivan too, just this morning, people agree there should be some rules and a premise permit in this case. But when push comes to shove, when you get down to either the very remote place that Dr. Drusies referred to couldn't be found, or the operation that doesn't have a premise permit and doesn't have a veterinarian, or at least a known veterinarian doing oversight, at a certain point, I think there is that entity. I think it's out there, and there probably is a reason there isn't a veterinarian willing to provide oversight for all kinds of lack of control, lack of physical presence on the site. And so I just wonder, a different statutory or regulatory framework should be considered. That just sounds like magical. It sounds like we're never going to find that.
I think what I heard earlier was, let's not worry about it now. Let's put out there the minimum standard, and then if these places exist, let's address it then. Well, I won't say what I wanted.
Other comments amongst the committee? Comments regarding the concept of developing minimum standards from the public? Okay. Do we want to just keep chatting, or do we want to have a motion on that at this stage of the game? Yes.
I like David's comment about starting with this committee, forming, we've got the format to follow. Let's get some work done and maybe a subcommittee, or I think that could be the most efficient, and get a report back to the next meeting, so then we could have input, and then if necessary, go out to a larger group. I don't think we need a motion for that, do we?
It would be nice just to have it on the record, I think.
So move.
Second.
Discussion from the committee? Yes, Dr. Druces.
So I certainly don't want to interfere with the motion, but do we need any guidance or permission, if you will, from the Veterinary Medical Board to proceed as such, or have we been granted carte blanche to deal with this issue and then make recommendations to them?
Yes, the answer is yes.
The latter.
Right. So when this was delegated to the MDC as an MDC priority, it was to work with the stakeholders and address minimum standards for shelter medicine. And that's exactly where we've circled back to. I think the scope got broader as we brought people in, and there were other maybe suggestions and recommendations made, but now we're back to exactly where we started with the recommendation, which is minimum standards of shelter medicine.
Just want to make sure we're all on the same page.
My plan tomorrow when I report to the board is to make sure that they still agree that that's the direction we should be going in. So I will ask for their blessing.
Excellent.
Okay. Comments from the audience on the concept of developing minimum standards and the motion and the second that's on the table? All right, let's vote.
Dr. Klingborg.
Aye.
Dr. Druces.
Aye.
Dr. Pollard.
Aye.
Dave Johnson.
Aye.
Jennifer Laredo.
Aye.
And Dr. Sullivan.
Aye.
The motion carries. So we're on to page 3, item number 2 of this. Yes. I will be creating a subcommittee. Yes. I don't always create subcommittees in the meeting. After careful cogitation and arm twisting and lots of phone calls, then subcommittees are created.
But if you don't do it at the meeting, there's no room for bribery.
Well, yes. So in the interest of full transparency,
Oh, okay.
yes. So agenda item number 2, or sorry, not agenda item, but item number 2, definition of the animal shelter. Again, the question has come up, and we've heard a little bit already today. We've got a recommendation here that came out of that committee meeting that would define an animal shelter as any city or county animal care and control agency, public or private organization that contracts with the city or county to house shelter animals, or nonprofit SPCA or humane societies incorporated under corporation codes, and there's some sections there, as societies for the prevention of cruelty to animals. There was not unanimous agreement in that meeting to this language. So we have a task here about defining what constitutes an animal shelter. I'm not sure that the subcommittee that may have some opportunity to further modify that, but I thought we could discuss this here and try and get some clarity on this. Any comments from the MDC on this language, particularly the underlined language that includes nonprofit SPC or humane societies? Yes, Dr. Pollard.
I have a question for CVMA, for Val. Could you explain why the CVMA hasn't signed off on that definition?
So again, I don't believe that it's, and I'm not sure whose purview it is, but I don't know that it's the purview of the VMB or the MDC to change the code definition of a shelter, because the board, to me, really has oversight of the premise itself where veterinary medicine is being practiced, not an animal shelter as a whole. There have been a lot of issues in the past regarding municipal shelters versus rescue nonprofits. In fact, there was legislation a few years ago that directly affected the investigatory authority of the Veterinary Medical Board over nonprofits. So I don't think that we felt comfortable, because this is a code change, because the definition of a shelter is not just about veterinary medicine. If you've ever seen the animal law handbook, it's that thick. And that definition could affect a whole lot of other parts of the law that we as the CBMA are not prepared to address. I would want to see an entire legal review of what that definition could change before I would feel comfortable asking my board to sign off on it. So we just think that at this point, it should remain as is until we got further information.
Yes.
Erica Hughes, State Humane Association of California. I just want to clarify that that our recommendation was to define shelter as this for the purposes of what we're doing here with the VMB and looking at minimum standards for shelters. We want to make sure that those minimum standards apply to both public and private shelters. So we're not looking at doing a global redefinition of shelter. And in fact, I don't believe there is a definition of animal shelter anywhere in the code. There are definitions that you know, for certain code sections, but there's no overall definition of animal shelter. So just to clarify, it's just in the context of what we're doing here that we want to be sure to include SPCAs and humane societies.
Dr. Sullivan.
I'm not sure that in that case we need to do anything with this section, because what authority we do have, or what under that section that Val was referring to, is 4809.5 inspections. So the board's inspections authority does not extend to premises that are not registered with the board. So if they have a premises permit, then we have authority to inspect them. So I don't think it matters whether they're how you define shelter then. As a matter of fact, if they don't have a premises permit, we can inspect them anyway. So I'm not sure we need we need this change.
Before this gets out of hand, it's not that we can't inspect them. It's that we can't go in on inspection
Routine.
authority only. We can
Right.
go in under an investigation with an inspector.
Yes.
So that's not to say that just if a place is practicing veterinary medicine and doesn't happen to have a premises permit, the board still has authority to go in, but it's under investigative authority. So I don't want to confuse that issue, especially in a public meeting. The other point I want to make, really to respond to Erica, is, Erica, you're absolutely right. My understanding of why we needed to reframe what we consider a impounded location where animals are impounded by state, county, city, or county agency has to do with 4840, and that's because they're not necessarily the city, county that's actually running the shelter. They're contracting with these other entities to run the shelter. So this was just for clarity purposes to include these other agencies that contract with the city and county that actually run the shelter, that they, one, have to have a premises permit, and two, the board can go in and routinely inspect those. So it's to the board's advantage to clarify that. You may not necessarily have to do it in statute. Dave brought up a very good point. If you're going to write minimum standards for animal shelters, perhaps that's where that definition comes into play, a new 2030, where you start by saying this includes all city, county, and those entities contracting with the city and county to provide, veterinary medicine to impounded animals. And what that does is it links that, not just sheltering, because sheltering isn't under the purview of the Veterinary Medical Board. It's that veterinary medicine is practiced in these entities, or at these entities. So that might be a better solution than changing 4840. But Eric, I agree with you, there is a need to do that because it has been unclear, from my understanding, in the sheltering community, that these nonprofits that run shelters, because they contract with the city and county, either feel they're exempt or that they don't fall under this definition.
Dr. Dreesies.
So as I see it, another complicating issue that maybe would be clarified with the minimum standards discussion, is verbiage that's currently in or proposed on the various other minimum standard categories that we are evaluating, is the language that indicates consistent with husbandry standards and shall be comfortably sanitary and provide for effective separation of animals and waste products. The argument may come down to, well, the board has purview over where veterinary medicine is practiced in its strictest sense, injections, medications, other treatment modalities, as opposed to where the animals are actually housed. And there are, I've witnessed them, there are facilities where the hygiene is absolutely terrible, where there is cross-cage drainage and contamination. Those areas should be the purview under a minimum standards of a shelter situation. They must be included in what gets evaluated, because to not do so is, I believe, a dereliction of duty on our part relative to the health and safety of the animals that become impounded in those types of facilities.
So I know there have been in the past different experiences on inspection. I know when our inspectors go into shelters today, they inspect the entire facility because there's not a separate building where the animals are just perhaps boarded or sheltered.
Au contraire.
It's, so this is what's happening today. I don't know if that's not been your experience, where they don't go into areas that you say there is no veterinary medicine occurring in this area?
Well, let's be clear. I've been always fully cooperative with any inspector that showed up. We have, and we may not be the example everybody we should be talking about. Our shelter is separated from the clinic and receiving area to where the animals are. There are separate buildings that house the animals. I have never said that they could not go there, but the inspectors, and believe me, I've been inspected a bajillion times, they are free to go anywhere they want in any of our shelters. But I'm not sure that's the case elsewhere, because for that exact reason, it's a separate door, a separate building. It's completely separated from the rest of the real veterinary activities, if you will.
So perhaps that would be a gigantic leap of authority, because when we go into private practices, if they have a veterinary practice and they have a boarding facility that's separate, we don't have the authority to go into their boarding facility. So I don't know how then we would say, for a shelter situation, we have the authority to go into both the clinic where they're practicing medicine and where animals are just being sheltered if no medicine is practiced and it's a separate building.
I don't think it's an oxymoron that we're discussing animal shelters. These facilities, that's the purpose, is to shelter animals. In the process or best practices, it dictate that they practice some level of veterinary medicine. Where those animals end up in the big picture, whether they have significant injuries or medical conditions that warrant closer observation, they stay in the clinic area, or they go to some other kenneling area, whether it's separate or attached. It really depends on, it's a case-by-case thing, and the volume of animals that they're handling at any particular time. I took this language directly out of the proposed languages for all the other minimum standards that we're looking at.
Very
So if it's a
familiar with
minimum standard for small animal practice,
In the veterinary facility, though. So what I'm saying.
separation of
Right.
animals and waste products.
Exactly. And what I'm saying is, and I think, Dr. Sullivan, you have a boarding facility?
Yes, but not separate from the clinic.
Okay, so we would inspect all of Dr. Sullivan's facility because his boarding services are included within the hospital. But in private practices where the boarding facility is separate, we don't have the authority to go in here or into that boarding facility. So my comment to you is, whether it should or shouldn't be, we're talking about the authority of the board to go into a facility that in that facility does not practice veterinary medicine. And that's where there may be an issue. And so that's something we need to keep in mind.
Well, I mean, maybe we need a little more time to ferret this stuff out, but my point, and Dr. Sullivan's point, I believe, is that this is a herd management situation. Animal shelters are herd management. And just to use parvo or panleukopenia or whatever other infectious disease you want to use, you cannot be doing the system justice, especially with parvo, when you've got a facility that potentially has cross-kennel drainage and contamination of the entire herd that's there. It is the obligation, I feel, of veterinary medicine to protect the animals from those situations. However we need to be able to do it, I'm just suggesting from my perspective, that needs to be an integral part, because I have been to shelters that have problems, whether it's kennel cough or parvo, that the hygiene is absolutely terrible.
Right, let's go with Dave Johnson and then Erica and Eric.
I agree with some of what you said. And the, Anne-Marie, I think it boils down to, we back up a little bit, and then you get your minimum standards established, and then you train the inspectors what to look for and what areas to look for. I've been through 3 different inspections at 3 different facilities. They looked at the medical housing. They did not look at the standard housing for wellness animals that were just on the adoption floor.
Right.
And that's where they drew the line. Now, whether they were instructed to do that or they just knew that on their own, the line was drawn. They did ask about intake protocols. They did ask questions about sanitation. But the only animals they truly looked at were those under veterinary care. None of our animals were housed in separate facilities. They were housed within the shelter environment in specific isolated locations. But you know, it was a 10,000 square foot building, of which maybe the medical ward was 1,000 square feet. So they didn't look at the other 9,000 square feet. So I think that's just a training issue once the minimum standards are established.
So I would start and echo, I think, Dr. Drusi's concerns for appropriate care, sanitation, and responsible management of animals within the shelter. And I think that there is a role at some place to try to establish and work towards that. But I would question whether or not this structure is actually that place. And I would look at I would actually think this is one of those unique areas of sheltering that's a little bit different from practice medicine, in the sense that I think there's a distinction between veterinary care and sheltering, and I think the sheltering is separate. You have to keep in mind the origin of these animals and what becomes of them. They come in, they receive some veterinary care, and that may be as little as receiving a vaccination, which we've built into the idea that those facilities that are just simply doing intake vaccinations need to provide establish a premises permit. Those are sort of those things which in a private practice the animal would be immediately discharged back to their home. They'd be vaccinated, sent home. They may receive antibiotics for a minor wound, treatment for an ear infection, something like that. It is then incumbent upon the owner within the context of their home to pursue that care. These animals, by their very nature, have no place else to go. It's incumbent upon these organizations, the humane societies, the animal care control organizations, to continue and house those animals. But the housing is really separate in the sense of their obligation from providing the veterinary care. So while I think that there may be a place at some point for discussion about what standards should be set on shelters, I'm not sure that within the context of a veterinary facility is quite the appropriate spot. There are, as Dr. Drusi's indicated, many shelters that have very antiquated designs. Mine is probably one of them, built back in the 1960s, 70s. Communities struggling significantly to build and upgrade shelters because of the significant costs that are there. And if we start, trying to look at what sort of drainage and HVAC systems are established within shelters, I think that I can be very clear. I think there are going to be many that we would find that would have trouble meeting the same standards that we would want to put onto a modern and appropriate veterinary facility. It may be more appropriate to look, as I think Mr. Johnson mentioned, at the medical housing, those animals which are receiving more intensive care within a medical context, as opposed to those which are simply released back out to the main shelter population and perhaps provided an antibiotic twice a day or something along that line.
And I think it's, Dr. Drusi raises an excellent point, and that's that, there are many shelters out there that are operating in, suboptimal conditions, which raises the question of whether there should be oversight of shelters generally, not just in terms of the sort of oversight we were initially talking about in terms of veterinary care, but whether there should be perhaps a state agency that provides oversight to shelters with respect to all of the things that go on in shelters. And I think it's an important question, and I think it's something that the sheltering community is certainly interested in exploring. So I think as we move forward here, I think at some point a decision's going to need to be made as to whether the VMB is, going to be used as that agency that's overseeing shelters and what's going on in there, or whether it makes sense to have a different state agency that is charged specifically with overseeing shelters and has that expertise and that knowledge that's required to do that. I think at some point when we're talking about shelters in the VMB, it feels a little bit like trying to fit a square peg into a round hole. And I think the goal here should be to try to work within the confines of the VMB as much as we can, but to keep open the question of whether or not the VMB really is the appropriate agency, or whether we need to try to lobby our government to create a different agency for animal shelters like they have in other states. But I do want to say just one last thing in response to what you said, Dr. Drusi, is I know that there are a lot of shelters that do not allow inspectors into the non-medical areas, and I think that's going to raise a lot of issues. Not that it's not a good conversation, and I'm not saying that people aren't necessarily going to come around, but I think there are I think it's fraught with a lot of issues that would need to be thoroughly vetted.
Anything else? So let's kind of want to circle back to what we're doing here, which is talking about this definition of an animal shelter. We sort of segued onto a minimum standards issue and inspection authority, and I just have to say, as I've listened to it, if we have two buildings side by side, a shelter where one does just the veterinary care and the other one houses animals, then I can understand that there's no inspection authority of the one that just houses animals. However, if the animals are rehabilitated in the veterinary facility and moved over into the other building, that then does become a herd health issue. You do have disease processes, we have incubation periods, and I guess I'm unclear if the populations commingle, why there isn't authority for an inspector to go in and look and assess those facilities and get to the issues of sanitation and hygiene that you're talking about. So giving that editorial, I do have the question here for me as we look at the recommendation is there is underlined language, and I think what's key about the underlying language that was offered about nonprofit SPCA or humane societies is that those are private facilities that are not receiving public funding. So we really have a couple of entities here, those that do get some sort of public funding, whether it's via contract, and those that are private facilities. So my question for this committee is, do we want to consider both those public facilities or private ones that have contracted with the public entity? Yes, Dick.
Well, maybe I didn't express myself very well, but why do we care if they have to have a premises permit? If they have a premises permit, whether they're one entity or another, we have the right to inspect them.
So is an animal shelter then, is it independent of whether or not they're receiving public money? That's ultimately the question I'm asking.
I think you need to look at it the other way. You're close. I always look at it in terms of function. So if you are impounding the public's animals, then it should fall under the premise permit because the board's role is to protect the public's animals, okay? So if you're impounding, and impounding is very well defined, the book that Valerie discussed earlier, this is all the laws of the land for animals, defines impound, defines animal control function. That's the other way to look at it. If you are providing animal control functions, you're impounding the public's animals. If you're a humane society doing humane investigations and seizing animals under 597, you are impounding or taking into possession the public's animals. But if you're just let's just say, an animal building, for the sake of discussion, and you get voluntary deposits of animals, not involuntary deposits of animals, but voluntary deposits of animals of people that just want to relinquish their ownership, you probably don't need a premise permit. You're not providing any services to the public. They are giving you possession of those animals. If you're not running a vaccination clinic, if you're not doing animal control functions, if you're not seizing animals under humane investigations, that entity, whether it be a rescue group or whether it be a pet store or a private Dave Johnson's pet business, because we are going to see privatization of things, not just government or nonprofit, those probably don't fall in the need of having a premise permit. But once you start doing things to the public's animals, either running that vaccination clinic, running a spay-neuter clinic, impounding animals that are running stray via contract, those are all the things that the board should be involved in. That's how I see it.
Within my community, we've had two different private shelters where I saw the most egregious incidents of poor sanitation and
Right.
disease, but it sounds like you're stepping back
No,
from.
but did they have a contract for animal service functions?
No, they did not. They were private. The people were dropping their animals off or tying them to the fence, basically, and driving away.
Right, and technically, that's a stray animal that they should not take in unless they have an animal control contract. They should have returned that animal over to an animal control agency. Now, if the
They would
public shows up.
rehab some of them and then sell them, so. it would
And that
be-
happens all the,
yeah.
unfortunately, that's the dirty side of the animal sheltering business. That happens all the time. Ethically, those animals should go to an animal control agency. They should only be taking in owner relinquishments where you have a contract, where you come in, you don't like your dog anymore, and you give it to my agency, then it becomes my possession. And I think those that purely are doing that function alone don't need a premise permit. We've got one right in San Diego County. They're a wonderful little humane society. They offer no services to the public. The only animals they take in are animals that are given to them so that they are the owners of. Now, they have their own veterinary hospital, they have their own veterinary services, so even if they were required to get a permit, they would be eligible, but they don't need one, based upon the fact they're not providing services to the public's animals. Now, that's going to be a legal question that needs, I stayed at a Holiday Inn, so that's where my legal opinions come from.
Well, when I go to the gratuitous deposit statute under the Civil Code, that's 1846, subdivision C specifically says that if the gratuitous depository of a living animal is a public pound shelter operated by society for the prevention of cruelty to animals or humane shelter, that depository has to comply with the requirements of the Food and Ag Code. There's no mention of the Business and Professions Code. So, yeah, I mean, it seems like there's already a line there.
Dr. Druces.
Yes, I don't like to argue against myself, but I will. The alternative, and there is an alternative for exactly those situations where a group of individuals, like-minded individuals, or one person obtains owner-surrendered animals. Most jurisdictions have ordinances in effect that limit the number of animals that you can have on a particular zoning for a particular property. Any animals in excess of that, you are required to get a kennel permit. Those kennel permits are generally regulated either by planning departments of the city or county, or are regulated and enforced by the animal control jurisdiction. So there is that mechanism. Certainly, that's not the practice of veterinary medicine, but there is like a fallback position for those situations. The only problem is that a very small percentage of them actually have kennel permits. Most are in violation of all this stuff until they get caught by animal control because the neighbor complains about noise, aromas, and things of that nature. So I guess we can all be confident that there should be a mechanism to keep those situations under control, but that's oftentimes not the case, unfortunately.
And Dr. Dursey is correct. In San Diego, the Department of Animal Services issues the kennel permits, does the inspections. There's very specific sanitation guidelines, housing guidelines. Once it exceeds 6 dogs, then they have to have a permit. So there's oversight by an animal control agency. And then, Dr. Klingborn, in your situation, if there was a private organization that had horrible situation, a humane organization, Humane Society could come in and investigate. That would be the oversight. And that happens quite common. These rescue groups, there's hundreds of them. Some citizen has something, they call in a complaint, and it prompts a humane investigation of the care of those animals. I know several that are going on right now against rescue organizations where someone has complained to either the Humane Society or the Department of Animal Control, and an investigation is taking place about the care of those animals outside of the purview of the veterinary board. So there is some oversight. It's not a perfect system. And it's like anything else. The veterinary board doesn't get involved till someone files a complaint. And it's the same thing in the animal control and the Humane Society world. They don't drive around all day long as the police looking for something. It's usually the complaints come to them.
The analogy I'd love to make is pizza. So a cheese pizza, a product that you can buy like frozen in the supermarket, a cheese pizza is regulated by the United States Department of Agriculture. If that same pizza has a slice of pepperoni on it, then it becomes regulated by the Food and Drug Administration. So we may find ourselves, actually we have found ourselves in that type of situation, trying to cut across the gray area that divides or defines these various operations.
I'm concerned about what it sounds like a sentiment to exclude private shelters from premises permits, because I think that we're seeing, no? Okay, so then I'm confused because.
I'm just stating my opinion. A private shelter that doesn't offer any services to the public's animals, why should they have a premise permit?
Because those animals and the people that have left them there, we're talking about citizens of California.
We're talking about animals that are given to them and that they now own and possess.
Okay.
It has legally been given to them.
So they
If a
are.
client comes to your
There's an
practice
owner
and
exempt.
gives you their dog and you agree to accept ownership of it, it's now your dog.
But if I have 25 dogs, where do we cross the line
The
where?
county would come and
Yeah.
get you for not having a kennel permit.
I'm not looking to get the board in the business of being the overseeing entity for shelters, but I think we're seeing the public is using more and more private sheltering because of no-kill sentiments and things of that sort.
True.
And-
But there
and-
are private humane societies or shelters out there that are doing wonderful jobs that do not offer any services to the public other than adoptions.
I did have one question, and under this phrase here, where it says under corporate code 10400, I assume that's not restricted to nonprofit SPCA's and humane societies. anybody could do that, correct or not? That's what I don't know.
Well, I think this limits it to, that's a qualifier of the nonprofit SPCA or Humane Society that is incorporated under that code.
Okay, but
So it's not
could
and
an
anyone
individual
incorporated.
incorporate under that code?
And then call themselves an SPCA or
No,
Humane
call
Society?
themselves an animals.
Rescue group.
A rescue group, yeah.
Right, but I don't think this definition would include them.
Okay, that's what I'm asking.
Yeah.
Right, rescue groups are provided for, I think they become a 503C.
501c3.
They don't have to
Yeah.
be.
But not all are.
Right.
501c3 is
So
just a
10400 under the
Federal,
Corporations
It could be a
Code
for-profit.
Yes.
provides for corporations for the prevention of cruelty to animals being formed by 20 or more persons. So that's more than one. I mean, if we're trying to find, what are the restrictions on forming under 10400, that's it. It looks like you have to have at least 20 people involved with a corporation.
Erica, and then Bonnie.
I just wanted to say that I think this highlights yet another area in which the VMB doesn't fit very neatly with animal shelters, that certainly from the animal's perspective, whether for the dog, whether the dog is sitting in the county shelter, I'll just use my county, Contra Costa, sitting in the county shelter in Martinez, or sitting in the Animal Rescue Foundation, ARF, which is a very nice shelter in my county. It doesn't really matter from that animal's perspective. So I think, it may not be the VMB, maybe it's something else, but I want to underscore the importance of looking out for these animals and whether they're in private shelters or public shelters. And I also just, Mr. Johnson, I had a question for clarification. So in your scenario with a private shelter that's not offering any services to the public, and you're maintaining that it shouldn't have to have a premises permit, if it's administering vaccines, treating for parasites, do you maintain that same position because they would then fall under the owner exemption to the
Right.
practice?
I mean, I own a dog. I can vaccinate my own dog. I can worm my own dog. I can buy medications over the counter. I'm not practicing veterinary medicine. I have one dog. Actually, I have three. And I can't get any more without a kennel permit. But if I had 20 dogs and I was a private humane society or a private animal shelter or whatever we want to call, it's the same exemption. They own those 20 animals.
So, I mean, I think if an argument can be made that animals in the public, in these private shelters, can receive vaccines and treatment for parasites without veterinary oversight, I feel like the same argument could be extended to animals in public shelters, that they also should be allowed to receive those services without veterinary oversight.
Other than the ones in the public shelters are presumed to be an owned animal until proved otherwise. And that's the difference, is you're dealing with a potentially public-owned animal that its outcome has not been determined yet, or its status has not been determined.
Okay,
I-
so,
I
mean,
agree-
I mean, then we have
and-
this, but then we have this sort of bizarre
Oh,
result
there's a-
where an
there's a double
animal has
standard.
greater protection when it's a stray than
Sure.
it does when
And-
the holding period's
and
passed.
Don't get me wrong, I'm not saying that there should be different levels of care. I agree with you. There should be oversight of all the animals. I think they all deserve veterinary care. They all deserve to have some degree of oversight. Unfortunately, a lot of the oversight for animal shelters is through food and ag, which doesn't do anything. There's no shelter czar. And so the veterinary board only has limited authority in what they can have oversight. I'm not downplaying the importance of it. I'm just trying to keep the discussion on what the veterinary board has the authority to do. And I don't think they have the authority to get into the private exemption area.
Okay, so I guess just in my final comment is, again, I think we need to look at whether it makes sense to be doing this piecemeal oversight of animals and whether we should be looking at another agency to oversee animal shelters.
Let me ask you a question. Is there a reason that the two main shelter organizations hasn't approached Food and Ag and said, hey, this is 2018, it's time to kind of clean up the regulations, some of those definitions in there from 1872, and maybe we need to have more Food and Ag involvement in the oversight of shelters? Has that been a political possibility?
I think it's a political possibility now. I don't think it, I think it's, people are warming to the idea over time, and I think it's garnering more and more
Right.
support. There has been talk of doing comprehensive legislation that would involve not just animal shelters, but also boarding facilities, rescues, groomers, everyone that interacts with animals other than veterinary hospitals. So, no, I mean, I think that that's on the table, and I think it's something we're looking at.
I would encourage you and support you.
And I understand from the other states that have it, it often works quite well. And people who come from, people who work in sheltering who come from states that have that are very shocked by the fact that we don't have an agency that oversees animal shelters. So.
Dr. Sullivan and, Ms. Lutz? Yep.
Oh, I just think we have to keep focused on the fact that we're talking about the definition of an animal shelter here. And my concern, we can talk all day about premises permits and the owned animal exception, but I don't really think that's what we're talking about. What we're talking about is, should we include with animal shelter these SPCAs that don't impound animals? I mean, impound is very well defined. It's very clear what an impounded animal is. There's a lot of SPCAs that impound animals, and then there are SPCAs that don't. And not to get into the owned animal exception, that's just a big exemption. That's just a big deal. My problem with all of this is I don't really want to see any of this dumbed down. I mean, I don't want to see this special minimal standards for shelters sort of dumbing down the care that the animals get in shelters. And what concerns me is that if we include these other nonprofit SPCAs, now forget the owned animal exception, but assuming that these other SPCAs have premises permits because they're providing vet care, I don't know that they really should fall under. I mean, isn't the whole purpose of this to be able to give a government shelter or a private shelter that steps in the shoes of a government shelter the opportunity to have standards that they have to follow when they take care of animals, when they provide veterinary care to animals? So if that's the purpose, then I don't think we should include these other SPCAs, humane societies, that don't impound animals, because they don't have an issue. They can have a premises permit if they provide veterinary care. If they want to take the chances with the owned animal, that's fine, they can do that. But to me, we're talking about trying to look at animal shelters, especially big government animal shelters, and see what we can't do so that they can provide the necessary care. And I really don't want to see that care sort of dumbed down or diluted out.
Good point.
Dr. Sullivan?
Well, I agree with that, and that's why I think we have the format in place of going to 1030 and going down that list and see what applies and what doesn't. I think that's how it should be approached. I have a question. I thought a bill was passed last year and signed by the governor to be able to inspect boarding facilities. Wouldn't that somehow set a standard for all facilities that house animals? I would think that's a fit. And who does that? Who does those inspections? I think it's local animal control.
Local ordinance. But it exempts veterinary medicine, yeah.
Any other discussion on this recommendation? We've been trying to work through the definition of an animal shelter, at least, I think, through the lens of what we would expect the VMB to have oversight. And so, yeah.
I'm going to go back to, I don't think we can inspect them unless they have a premises permit. And if they're doing veterinary medicine, they have to have a premises permit.
Okay.
I
And
think
so the
that's clean.
definition is moot. It's really just the veterinary medicine piece of it.
I haven't heard anything to change that.
Yeah. The veterinary medicine needs to have premise permit, so whether you're an animal shelter or live in a circus tent, if there's veterinary medicine there, you need to have a premise permit.
I'm going to make one comment, and just to keep this in mind when you're going through and creating minimum standards for the shelter, since that's where everyone seemed to agree that should happen. You can't look at the definition as a vacuum that stands on its own. This definition then feeds into what's into 4841 about the RVTs and veterinary assistants being able to work in these facilities and provide veterinary care through direct orders, direct or written orders. So the definition was intended to tie back to this quasi-exemption for RVTs, and we've been discussing veterinary assistants, to be able to do certain things on intake. So that's why the definition was important, because there was confusion about where that practice can occur. So when we take these issues one by one, we lose sight of the fact that they're all intended to create a framework. So that's just a general comment to keep in mind when you're moving forward with the standards. And Dave, to your point about whether we should change the statute or not, obviously this is something you're going to have to get legal guidance on, but veterinary assistants are not currently included in that exemption in terms of being able to operate without a veterinarian on site or a veterinarian providing supervision. So that then gets into, well, are we operating under some sort of indirect supervision parameter? And where that becomes dangerous is other areas of practice. So we really wanted to make sure we focused on this being specific to shelters and it being protocols, written or telephonic protocols. You very may want to look at that statute for the purposes of adding in a veterinary assistant, because if you start monkeying with your indirect supervision definition and trying to apply that, that's going to apply across the board in all aspects of veterinary medicine. So just keep that in mind when you're looking at whether or not there needs to be a statutory change.
And I think going back in our notes and minutes, I think we did make that recommendation for the veterinary assistant to be added. We just didn't make the recommendation that other agencies be added in there. So I don't think there was any opposition to adding the veterinary assistant part of it.
Well, it was just, this goes back to your comment, I don't think we should change, your comment was, I don't think we should monkey with the statutes right now, that we should work on minimum standards
Right.
through regulation.
That's correct.
I think that's one statutory change you're going to have to do
First, okay.
in order to fold in the veterinary assistants.
Are there any cleanup bills going through anywhere?
Yep, there's
Can you
cleanup bills.
hide it somewhere?
I can make a request.
I just want to highlight one more time that the recommendation of changing 4840 subdivision B that's currently in item 5 potentially closes the scope or limits the scope of what RVTs can currently perform on impounded animals. Because right now they can provide animal health care services. But if we take this language as it's been presented, that would limit the scope of RVTs to only providing necessary and prompt veterinary care. So I just wanted to remind everyone that if some kind of legislative solution moves forward, that there needs to be a little bit closer review of that language itself, so we're not cutting off our nose to spite our face.
Dave?
If I remember the discussion of the reason we switched is that no one could define what animal health care services were. It was just this nebulous concept, and so we went with necessary and prompt because that was language from another section of the statutes or the regulations. And so, yes, we could most certainly, in minimum standards, define animal health care tasks. That could become a definition. But that was the reason that whole discussion took place. We were just trying to make language match better.
To the civil code, yeah.
That was not a unanimous
No.
vote.
And that was not a unanimous vote.
Yeah.
Yeah.
And so, we're going to get sidetracked, but is worming medication, is that prompt and necessary? I
Right.
mean, I think that I do understand what animal health care services means. I'm not sure. I do think that prompt and necessary may be overly restrictive, but I'll get back onto
Good
the
point.
agenda. So at this stage of the game, any other conversation on the definition of an animal shelter This is instructive for this group. This is also instructive for the subcommittee, which will be comprised of 2 members of this group, and so it's valuable. But we don't necessarily have to put pen to paper at this stage. We just wanted to at least explore the conversation, understand the parameters. Are we good? Okay. Any questions from or comments from the public before we move on to the next issue, item 3? I can't hear you. We are leaving the definition to the subcommittee, and of course, the subcommittee then will come back with some language, and then all stakeholders will have lots of opportunity to comment. Issue number 1, well, let's just go to recommendations here. There was a recommendation here under the authority of RVTs and staff and shelters to amend 4840B, and it looks like, I'm trying to understand, okay, so I think we've had 2 changes in the language here. We have from 4840B, language that was offered through CVMA's premises task force that did include the veterinary assistance piece, as well as the necessary and prompt veterinary care that we voted on last time. And then there's a second addition to the language now, which goes back to the discussion we just had with inclusion of additional verbiage for what would define an animal shelter. So there's 2 changes to this language. I think that we are not at this point ready to accept the second change because we didn't accept it in the part that we just had. Is there discussion, if we just leave that piece alone for right now, about the registered veterinary technicians, veterinary assistants, necessary and prompt veterinary care? Yes, Dr. Sullivan.
Being cynical that I can be once in a while, when I first looked at this, I was thinking, what shelter would ever hire an RVT with this statute? Why would a shelter hire an RVT if a veterinary assistant can do all of these tasks?
Yes.
What makes a person who works in a shelter a veterinary assistant?
That's a veterinary assistant, with all due respect, is yesterday one's unemployed person. So yesterday they were unemployed, today they work as a veterinary assistant. Unfortunately, no, unless we follow the guidance of the CVMA and their certified veterinary assistance program, which commercial for them is absolutely terrific. The example I think that Dr. Sullivan brings to light is an example that I have often brought before this board, Blythe. We have a shelter in Blythe. There's not an RVT within 100 miles of Blythe. We impound, 500-600 animals a year in Blythe. I have an office assistant that's gone through the CVMA veterinary assistance program. Her and an animal control officer are the ones who provide prompt and necessary veterinary care subject to written protocols that we've established. That's exactly what happens.
Well, it seems to me those people should be called shelter staff and not veterinary assistants.
Well, I think there's a difference between job descriptions from a legal standpoint and what actually gets the work done. But we don't have the budget to have more than 4 employees at that location on a 24/7 operation.
Jennifer and then Dave.
I just wanted to point out, I definitely see Dr. Sullivan's point that I'm more expensive than a veterinary assistant would be, so why would they want to hire me? And I agree that we don't want to make it okay for veterinary assistants who are not trained to treat these animals, but the shelter I work in is not the example. There are so many shelters who just don't have RVTs, who don't have the budget for it, And again, we have to take care of these animals no matter what type of a shelter they're in. And I think vaccinations and deworming, not that they are not dangerous, but it is more dangerous not to vaccinate and deworm these animals on impound than to allow possible cross-contamination and herd health issues.
But they still don't need to be called veterinary assistants if they're not veterinary assistants.
I think Christy isn't here today, but we had the big discussion that one time that anybody who is not an RVT or a DVM is legally a veterinary assistant, so.
Who works in a veterinary facility?
Right, our guard
Not
at the
who
front
works in a
desk
shelter.
is legally a veterinary assistant, anybody who is not licensed.
And to answer that, any place that has a premises permit is considered an animal health care setting, and that, so as an animal health care setting, they would be considered veterinary assistants. We don't regulate shelter staff. So if you want to create a title, it wouldn't be under the purview of the Veterinary Medical Board.
I think this is an extremely dangerous situation you're creating where you're equating a veterinary assistant to an RVT in a situation where there is no veterinarian present. I mean, this is a situation that requires more knowledge on the part of the person who is not the veterinarian, not less. And so I would caution that. Be careful where you go.
Dave? Okay, Jennifer?
Just to finish my thought, and Nancy, in my shelter, we have RVTs and we have veterinary assistants who work with us in the clinic and treating. We do have people who are legally veterinary assistants who are called kennel attendants and shelter staff. It's just that legally in the Practice Act, there are RVTs and veterinary assistants, but in the shelter world, they do have other titles.
Dr. Sullivan?
I think I would feel more comfortable, I mean, we're talking about statute here. I would feel more comfortable of redefining it a little bit in that registered veterinary technicians may perform necessary and prompt veterinary care, and veterinary assistants may do what's defined in regulation, and then go to regulation as the example we have, which defines pretty closely what a veterinary assistant can, or whatever we're going to call them, can do. I like to narrow what a veterinary assistant can do, but I'd like to do it in regulation rather than in statute. That's going to be a lot more difficult to change.
I guess as I read this, and it's kind of lost now because there's this big chunk of extra language that's been put in, but let's keep in mind that what the RVT or the veterinary assistant is doing still is under the supervision of and delegation of a veterinarian. So, this is not necessarily a blank check for a VA to do anything and everything that an RVT is doing. I'm assuming that the protocol that the veterinarian would write would say RVTs can do this, but not veterinary assistants as well. So I don't know that this is removing anything or disrespecting the skill set of the RVT, but that's up to the supervising veterinarian to choose appropriate levels of supervision and delegate properly.
But it doesn't say, it says that in regulation, it doesn't say it in the statute, though.
So we do have language as our last agenda item today that actually strengthens the supervisory responsibilities of the veterinarian.
Oh.
And so, I think that we do recognize there are some shelters that don't have RVTs that are going to have veterinary assistants, but, let us hope that the veterinarian's not delegating improperly to the veterinary assistant. We still, the authority still resides with the veterinarian, though.
Yeah, I've been inspected twice without any problems.
Yeah.
Can I offer a solution that may bridge this? If we just said registered veterinary technicians and veterinary assistants may perform animal health care services as provided in regulation on those animals impounded by a state, county, city. Because then we are referring back to 2036 and 2036.5. So you could do that, and then the scope of what they do
It's much narrower.
is limited
Yeah.
to what's already provided in regulation. So you could potentially do that if that satisfies the concern.
Yeah, my concern is that broad category there, the necessary and prompt veterinary care. I think that's way too broad.
Okay.
So it sounds like, would you like to make a motion on this language? Yes, yes, yeah. Hi, Val.
Hi. So it was so long ago that we did this, I apologize for not remembering why we did what we did, but I know we had this conversation, and I'm not certain that statute has to be changed. So what we suggested was a change that would allow for RVTs to have more authority than veterinary assistants. And then we came back and had a very limited authority for veterinary assistants, and we cited 4836. And I will defer to the authorities on this, that we felt at the time that that could be done without changing statute. And I know you probably don't all have copies of what we submitted, but just in a nutshell, RVTs, and there's a lot of language here, and I won't read it all. We suggested that they had limited medical care could be provided in a shelter setting by an RVT for the specific purpose of controlling infectious and zoonotic disease, controlling acute pain, and preventing environmental contamination if all of the following are met. And then there's a series of items after that. And that the supervising veterinarian would establish written orders for vaccination and prophylactic control of endo and ectoparasites on intake and treatment of medical conditions based on an animal's symptoms. And that was for RVTs. Then we went back and citing 4836, felt that veterinary assistants could, with the veterinarians, establish written orders, be able to perform animal control services for vaccination and prophylactic control of endo and ectoparasites on intake, a much more limited responsibility for a veterinary assistant. And my notes here say that we cited section 4836. So I just wanted to tell you all that because I think at least that should be looked at before we go to a statutory change. Because once we do that, then it applies to all kinds of other things, and I'm concerned about going down that road.
Other discussion? Yes, Tara.
I'm a little concerned about blurring the lines between an impound, a shelter, and what should be a registered premises. Back to that, because we're now tapping in with this language on Civil Code, Section 1846, which requires veterinary care for those animals that are gratuitously deposited. What does that mean? Does that mean just the pound or the shelter? So now, with this language, we're potentially authorizing a VA or an RVT who just work at the shelter or the pound to start doing these types of services outside of what could be a registered premises. We're getting back to blurring the lines again. That's all I'm saying.
I don't think they're considering this language right now. So they're only considering it up to, my understanding of what we were talking about was registered veterinary technicians and veterinary assistants may perform either animal health care services or necessary and prompt care on those animals impounded to, without that additional underline, because that wasn't agreed upon. So
Okay.
we're removing we're not entertaining this, I guess. Is that what was happening?
That's right.
Okay. So it removes I think what Val brings up is whether or not there's authority under section 4836, in that it establishes a protocol between the, as Kurt would once say, the captain of the ship, and then you've got the, what's the next guy in line? You've got the captain, okay.
The chef?
The chef. I don't think it's the chef, but clearly
It's close to lunchtime.
clearly no one here is seaworthy, but we've got the next person in charge, which would be the RVT and then the veterinary assistant. So it sets up this hierarchy of who can delegate and who can supervise. And whether or not that provides authority for the board to then further define regulations by minimum standards for shelter, where a veterinary assistant could work under some sort of written protocol, but that is separate and apart from what an RVT can do. So maybe that's what the MDC can ask legal to look at, is whether or not there is enough existing authority in statute under 4836 to provide for regulations that allow a veterinary assistant to do intake and triage in a shelter, but does not in any way elevate them beyond what their current scope of authority would allow.
So we're not going to rewrite this today, but I do have a question for this group, again, to be instructive for the subcommittee. Do we want to itemize what registered veterinary technicians and/or what veterinary assistants can do? Or do we want, and that may just be pointing to a statute? I mean, the itemizing may just be saying, look at this. Or do we want to simply allow the supervising authority of the veterinarian to determine what they may do in this setting?
I still go back to the document that CVMA put together a year or 2 years ago. It spelled out pretty specifically, and I feel comfortable with the veterinary assistant doing those things on intake. And the RVT can do a lot more because they have authority to do more. So I like narrowing it down. I like, and I like the word, the verbiage that we've had before us in the past. And I think that's a good starting point. And I like it in regulation.
Any discussion, input on that?
I found the document. Advantage of keeping papers. It's got excellent structure to it and concept, and I think most certainly we should take a look at it and figure out how to incorporate it into regulation.
Okay.
Which document, Dave?
I
CVMA's document?
Yeah.
Oh, yeah.
It's the one dated 6/27/16.
Okay.
Right.
Is your microphone on?
Oh, I'm sorry.
Yeah.
It's a document dated 6/27/2016, page 2.
Yeah, we had it in our board packet,
Right.
or MDC packets
Yeah,
at
it's
the
in some
last
of the older
meeting.
packets.
Right.
Right.
Okay, so again, that's going to fall on our minimum standards, shelter minimum standards subcommittee, I think. But Erica?
I just wanted to say that we're talking about all of this in the context of a shelter that has a premises permit with a supervising veterinarian. And so it seems to me that there are a lot of shelters, particularly small ones, that don't have the ability to hire an RVT, but they still need to provide care beyond the immediate, there's ongoing care that happens in a shelter setting. And so if it's, if the supervising veterinarian feels that that veterinary assistant is qualified to perform certain tasks under protocol, then it seems that that's the call of the veterinarian, and that's kind of the whole point of this, I think, overall point of this discussion is that there is a veterinarian who's overseeing what goes on in the shelter. So it seems to me to be overly restrictive to require a premises permit with a supervising veterinarian and then also limit what veterinary assistants can do. I think it goes contrary to what we're trying to do here, which is improve the care of animals in the shelter and ensure that the care, proper care is being followed. And I think if we have a veterinarian in place, I think that's the insurance that we have for the animals in the shelter.
Dr. Sullivan?
Again, I think if there is protocol there and there is veterinary supervision, I don't think it's any different than a herd health situation where a dairyman follows the protocol that has been set up by the veterinarian, but the veterinarian is the one dictating that. It is a little different. I'm afraid, though, that the dairyman, that's his own animals, as opposed to a shelter is a little different. So I think we do need to look at that.
I'm just concerned about shelters like Blythe that don't have an RVT, that that the veterinary assistant there would only be able to perform those initial tests on intake, but then would be unable to perform any other veterinary care during the course of the animal's impoundment, even though there is a supervising veterinarian and written protocols in place, and the veterinarian's available by telephone also as needed. I think it doesn't acknowledge the unique needs of the shelters that we're trying to address here.
Other comments from the committee on this line item or public? Okay. All right, we're going to move to, we're going to finish this agenda item before heading to lunch. So let's move to the next item, which is rabies vaccine. The recommendation is the MDC should recommend that CCR 2035C be amended to state that the rabies vaccination may be administered to an owned animal upon redemption from an animal shelter without prior examination by a veterinarian. And Dave, some of this stuff came through from the subcommittee that you've worked on as well.
Correct, and this has been one that's been on my personal bucket list for a long time because of, as it states in the overview, every shelter handles the rabies vaccination and the impounded animal issue differently. Some vaccinate the animal and send it on its way if the veterinarian's not there. Others make the public come back at a different time, and others keep the animal for another couple days until there is a veterinarian there. And so again, it is a access to services issue, not just a convenience issue. Where it gets a little interesting is, Anne Marie, you had a very good discussion with Curtis Fritz of Public Health, the veterinarian in charge of the veterinary section of Public Health, and he seemed to be a little bit liberal in his interpretation. Is that something you want to live with? Because the next person comes in could be very conservative with their interpretation. So I'm thinking that it would be best to define it in the regulation to make sure that there is a point of reference, not just, hey, we had a conversation, so this is what we are going to tell everybody it's okay to do. And so that's why I think that we should go ahead and actually address this, but in a very narrow perspective. This is not running a public rabies vaccination clinic. This is animals being redeemed from an animal shelter that have been impounded that need that vaccination to get out of the animal shelter. It's a very specific type of situation. Not every one of those animals has been seen by a veterinarian. Every now and then you're lucky, and it was seen by a veterinarian, and so you're okay. But in many instances, as you heard from the testimony from the variety of people over the last year, every shelter handles it differently. Some of these animals are kept 2 to 3 days additionally, and so that gets back to that access of service issues.
So again, no, I don't think it's a good idea to rely on the conversation as the benchmark for how we proceed in terms of scope. But what was interesting about the conversation with Dr. Fritz is that, their approach to what is permissible or what DPH, Department of Public Health, would deem acceptable is that the veterinarian has trained these individuals to administer the vaccine. That there's training on the storage of the vaccine, how it's administered, how it's handled, how the animal's injected, and what happens from that point. Obviously it covers the age in which the animal may be vaccinated for rabies. But nothing about the fact that the veterinarian, they don't see their role, they see that as our role in determining the veterinarian's involvement in the care and treatment of the animal when a rabies vaccination is administered. They also suggested that there are a number of rabies certificates where it's a stamped signature of the veterinarian because someone else other than the veterinarian is administering the rabies vaccination and may not be on site when that certificate has to be handed over to the owner on adoption or whatever the case may be. So again, they didn't feel as though they would be the overseers of how involved the veterinarian is in the actual administration of the vaccination. You could amend 2035C. That's kind of a general provision on the duties of the supervising veterinarian over and we're actually going to be amending that section later. So perhaps it would be advantageous to include this as one of the other additional amendments to that section. You could also include it under a separate section in the minimum standards that you're thinking of writing for shelters, so that it doesn't apply, universally
Right.
to private practice and what have you. It's a minimum standard of a shelter. And maybe that kind of retains all of that in one specific section and makes it easier for people to go through that list. And
Right.
within that list, it's how is a rabies vaccination
Right.
administered in a shelter setting.
And I think that's very smart, in that to make public health happy, you outline the criteria of what has to happen, where the training is, what to look for, what are the responsibilities for, and again, that gets back to the minimum standards discussion, and that's a very specific task that occurs in a shelter environment, not in a private practice setting. And I think that's the avenue we need to take a look at.
Jennifer and then Dr. Druses.
I think this all comes down to the age-old argument, the letter of the law versus the spirit of the law, and the six of us sitting here today might interpret this regulation this way, and a year from now, when we're all gone, somebody might interpret it differently. So I think the question is, how are we going to all be on the same page when we're not all sitting here?
So we're back to the definition of an animal shelter, are we?
No.
No, hang on, well, but that's what it says here, and to Dave's point about the owner surrender animal shelter that doesn't provide services to the public, yet they adopt the animal out, are they going to score on a vial of rabies vaccine from their veterinarian who otherwise has no relationship to the physical structure of their animal shelter? And are we going to permit those veterinary assistants, not even RVTs, from vaccinating these dogs? Not that I'm against vaccination, but, maybe this is something that needs to be directly connected to a premise permit.
Anything in the minimum standards will be directly connected to a premises permit.
But that's not what it has here.
So this is just a recommendation, and we don't, we're trying to, because on the second line of the recommendation, the words "from an animal shelter" there.
Right.
But let us strike that and talk about a premise permitted facility. Okay? But is there still comfort level without that being done physically by a veterinarian? I mean, I think that's been kind of a bone of contention.
Well, I think we're talking about a greater good here, discussion. Certainly, the public health veterinarian in me would suggest that every opportunity we have to vaccinate dogs and cats for rabies, and we don't, is a missed opportunity. So my electronic signature is on every rabies cert that we issue, and I may be 60 miles away from the actual point of service.
Other comments? Comments from the public?
I just have one little comment, and that is that I think the way it's written, the recommendation confuses the VCPR with the level of supervision. So I think we need to be careful there. They're two different things. It says without prior examination by a veterinarian, that's VCPR related. I think if I'm listening to you correctly, what we're talking about is the need to do a vaccine when there isn't a veterinarian present. So I think we need to be careful that we're not meshing those two things, even though if we look at the definition of indirect supervision, that brings in the VCPR requirement, but I think we need to be careful of using this term without prior examination, because that kind of gets off of what we're not really talking about examination, we're talking about no vet even there, correct? Okay.
I think the language that ought to be on the table ought to say something to the effect that a rabies vaccine may be administered to any animal within a properly permitted shelter facility by a RVT or veterinary assistant. I mean, is that not what really the crux of it?
Conceptually, I like your idea, but the only animal that legally needs to be vaccinated is the dog. So a horse, you can vaccinate a horse for rabies, but it's not required to get your horse out of an animal shelter unless the cities have specific or counties have specific ordinances about cat rabies vaccinations. There's no state law requiring the cat to be vaccinated. Sheep can get a rabies vaccination, and you could get your sheep out of our agency without a rabies vaccination. So it's specifically for dogs for licensing. Conceptually, I agree with you. All those animals should be vaccinated to help control a disease outbreak, but it's specifically for dogs.
Sheep can get rabies.
Yep.
Yeah.
Yeah.
They're very mean. Yeah, yeah. Don't mess with sheep.
Don't ever
anyway.
cross a sheep.
Sheep are smarter than they look.
Especially if they have two testicles.
Indeed, indeed. So is there discomfort or anxiety here in any way with the concept of, within this shelter facility, a non-veterinarian giving a rabies vaccine under some form of veterinary supervision? I just need to understand where we are. Is that a deal breaker? A veterinarian has to be giving the vaccine or not? And if not, then what does that look like?
Not a deal breaker, but I'd sure like to have a letter from the Public Health Department defining what our role is, or, something in writing as to the conversation that you had. I would feel a lot more comfortable with what we're doing.
So it is in writing, it's in the minutes, and we also included it in Dave's report last time. I don't think they're going to give you a letter. They don't feel like this is their oversight, it's our oversight. So that was the conversation with the public health veterinarian today. I think your assurance would be you write the minimum standards for shelter medicine, and you include the administration of a rabies vaccination under delegation of a veterinarian to an RVT or a veterinary assistant, and send it to them, and they can publicly comment on that. That is where, back to Jennifer's point, regardless of whether we're all here or not, there'll be something in the minimum standards that will suggest that this was carefully thought through and that this is a minimum standard of a shelter that doesn't necessarily apply to all veterinary medicine.
Any comments from the public?
Lunchtime.
Okay, then I'm ready to close out this particular agenda item. Let us take 1 hour for lunch. We will start at 1:15.